Morning.
Thank you for coming. My name is Cheryl Harris, and it's my pleasure to welcome you to a panel that I'm sure we've all been looking at and waiting for. The significance of this case can't be overstated, and we're joined by some really thoughtful people who I know have some very interesting things to say. I want to get right to it, and so I'm going to dispense with the introduction. Please consult your programs for the illustrious backgrounds of all of our speakers today. We're going to proceed with them speaking in the order that's in the program. That'll be Professor Ruben Garcia, Professor Vinay Harpalani on my left, Professor Rachel Moran, and then Professor Susan Tanner. Each of them is going to be speaking for about 10 to 12 minutes or so. 15, hey.
We got extra time.
We're good. But anyway, 15 minutes roughly, and then we're going to open the floor for questions. I may take the prerogative of the moderator and start us off, but we all definitely want to hear your questions and comments. So with that, Ruben, would you like to take it away?
All right. Good morning, everyone. It's a pleasure to be here. I appreciate you being at this 9 a.m. panel, and very good to be back here at UCLA Law School. Today I'll be discussing the privileging of obstacle narratives embedded in the Students for Fair Admissions versus Harvard case that we're all familiar with. And so I just want to start by letting you know that the PowerPoint is in the box folder, and the clicker is right here, and so you can take a look at the slides online in the box folder, and you can, of course, know that this is a work in progress, and I'm looking forward to your feedback, and I definitely think that this is something that a lot of us are going to continue to be talking about and writing about, and so I think it's great to be here and to continue the conversation on this. So the abstract, again, is in your materials, but basically, because it's hard to read, of course, I'll just tell you that what the paper's about. What the abstract says, just summarize that. So the 2023 Supreme Court decision in Students for Fair Admission versus Harvard ended the use of race-conscious holistic admissions. However, the court left open a narrow pathway that institutions may consider applicants who have overcome racial discrimination or whose heritage has motivated their achievements. This non-racial off-ramp, as I call it, offers, of course, a limited and problematic view for promoting diversity. So my argument is going to be about the risks that, of course, that these non-racial off-ramps present, and for various reasons that I think many of us are familiar with, in terms of the obscuring the centrality of race in our society, and of course in the lives of many applicants for admission or employment for that matter. And it again is another example of what I think in many Supreme Court decisions seems like either an off-ramp or an outlet. You can call it anyway, a narrow path. You can call it any way you want it, but often I think our experience in many Supreme Court cases is that these off-ramps end up being dead ends or blind alleys. So the objective today is really to talk about how this particular off-ramp might lead to again, obviously not be as productive as the advocates of affirmative action might hope for, but also to argue that it is still a path that can be productive and justice-producing and diversity-producing, even in its problematic nature. So in this regard, I will go over in this presentation what SFFA actually did, or the very quick summary, because I think in this room I don't need to spend a lot of time on the history of affirmative action and the what the cases were before, but I'll summarize those briefly, then talk about the sort of the scholarly framework or conversation that I think this work sits in, and then again talk about the ways in which this particular decision may be employed by those wishing to have greater diversity in higher ed and in other parts of American life. And then, again, I'm going to talk about some ways forward after SFFA again, and even in the context of this limited framework. So, to start again, we are talking about the policy shifts in affirmative action over a good 50 years, more than that, and really, again, the policy shifts in terms of the government use of affirmative action, state institutions' use of affirmative action, and how the court has treated these efforts, right? So we know in the Supreme Court, most of those conversations start with the Bakke case and in 1978, and the Justice Powell plurality opinion in Bakke, which allowed for basically the holistic use of race as one factor, or use of race as one factor in holistic admissions, and its, of course, continued kind of refinement over those after that by different institutions who were looking to increase the diversity of their institutions without using quotas, which were prohibited by Bakke. So we have, again, the 2002, 2003, the higher education cases from the University of Michigan, which we know of, and again, the reaffirmation of Powell's plurality opinion as a majority opinion in Grutter versus University of Michigan Law School, but also the non-racial off-ramp, which we know of that Justice O'Connor left in terms of the shelf life or the expiration date of affirmative action being 25 years, which would put us again at 2027. And so we have, again, in all this time, of course, we have the different kinds of even when institutions are able to use race as one factor in a holistic admissions process, they also have, there are other institutions like in California and like in Texas, which are prohibited from using race, and so then use through state initiatives or ballot initiatives like Proposition 209 or Michigan's so-called Civil Rights Initiative. And we have, again, the idea that institutions have to use racial proxies to try and achieve the same kind of diversity. And, of course, the ones, I just talked about the ones that, some examples that, you're familiar with, I'm sure, sort of use of zip codes or income as proxies for racial diversity, right? So that's a whole paper and a whole literature in and of itself, the use of racial proxies in admissions and how many times they're ineffective and how they, again, elide the importance of the centrality of race in these institutions and in the lives of the people who were students. So we have, again, the racial proxies cases, Fisher I and Fisher II, coming to the Supreme Court, and really by Fisher II in 2018, we have the court actually approving the use of racial proxies in the top 10% plan of the University of Texas by saying that basically the Texas's goals were constitutional, even when, again, the goal is greater racial diversity, just without the consideration of race, right? And so everything would seem to have been pretty stable at that point, except that we had, of course, a conservative legal movement led by Edward Blum and Students for Fair Admission and other groups to try and go at Grutter and affirmative action directly, right? Holistic review of applications and Grutter directly. So they do. They course, take the Supreme Court takes the Students for Fair Admission versus Harvard and University of North Carolina cases together, and in 2023 they issued the opinion, as we know of, and that I've already mentioned, which prohibited the use of race in holistic admissions. And again, here I know there's a lot of folks in the room and in this conference, of course, who thought about these issues and written about these issues. So definitely appreciate you being here and appreciate your work on this. I think it's pretty clear to some of us, at least, maybe most of us, that the institutions are reacting to the admissions, to the SFFA decision in a lot of ways, and sometimes, as I think many of us would agree, are overreacting or overcorrecting for what the decision actually did. Now, this is, again, not to obviously minimize the place that a lot of general counsels are in and a lot of lawyers are in terms of trying to work within the bounds of this decision, right, in 2023. And so, but there was, of course, a lot of overcorrection, and that's another story as well, which we could maybe talk about. But the fact is, again, that this, even with that, on its face, we have this, what I call, again, obstacle narratives, what Justin Driver in his new book, The End of Affirmative Action, has called the, that's 5 minutes, wow. Okay, so I'll just sort of cut to the chase here. In terms of these obstacle narratives, I call them, or trauma narratives as they've been called, obviously we can think about the ways that is problematic from a critical race theory perspective, right? It minimizes or attempt to be colorblind, and at some level it's a focus on individuals rather than groups, as the court has said, is the goal of constitutional law. But we know, of course, also that most of these racial identities are part of group and collective development. And so, how do you separate the individual from the group in the applications essay? That's going to be, of course, the challenge for both lawyers and for applicants themselves. And so, at the end of the day, of course, we have these obstacle narratives being utilized, and also in a potentially just to further the sort of inequality that's already in the admissions process. And I think, again, we have a lot of data on the those who are well prepared or well coached maybe can use these obstacle narratives. Again, race identity is an obstacle that has either been overcome or that has contributed to the character. So again, just the idea of it, or the real framing of it by the opinion by Chief Justice Roberts, is really about the problematizing racial identity as a obstacle rather than it as a positive. And so the bottom line is what is the future of these for both applicants and for institutions in terms of these obstacle narratives? Well, I think and in the paper I talk about some of examples of these obstacle narratives, and I think that you have oftentimes they've been used I think for decades, obviously, in the admissions process, and to have them again sort of institutionalized in the opinion as sort of the only route is definitely I think part of the problem, but also part of the opportunity here. So when I talk about obviously when I think about the way in which admissions happens, and I think about the stories of applicants, I think that there are a lot of stories that could be considered obstacle narratives, but are also quite related to their individual applicants and their communities, right? So we've all heard the stories of the applicants to several schools who get into many elite colleges at the same time. There's several of these kind of students every year, and the fact is, of course, that they are also many times from, and that's why they're in the media, right? That's why these stories are in the media, because they're from lower income backgrounds, or they're from immigrant communities. And those kinds of narratives, I think, as an example, one student who got recently into 8 Ivy League colleges, and he was basically a student from an immigrant community in Newark, New Jersey, and he because he's in the media, and I don't have, of course, access to his application for admission or anything, but his story in the media was really one of these kinds of obstacle narratives, and yet inspiring at the same time, right? And so I think what that one example shows, because I only have 1 minute, so I have time for one example, it really shows, again, obviously the confluence of class and immigrant background and immigrant identity, when the student was basically saying, well, I'm glad that I've gotten into these colleges because not many people from our community get in, and I think it shows, that my parents, really their sacrifices they made. I would like to, thank them basically for providing that kind of support. And so he was really sort of talking about it, of course, as an individual, right? How his personal circumstances affected his, what he was trying to do in terms of telling his story, which I'm sure he, again, told his story in the admissions process. And it really, obviously shows race and class and my immigrant background as possible obstacle narratives, but also as possible sources of justice and sources of, obviously, of individual achievement that Justice Roberts says we're supposed to continue to allow. And so again, the bottom line is, although these are problematic in many ways, these obstacle narratives, they still do provide a limited outlet, a limited avenue for more justice, more diversity in the admissions process. And I'm out of time, so thank you very much.
Thank you, everyone, for being here this morning. So my presentation, Anti-Asian Animus and Elite Admissions Controversies. So I'm going to talk about the role of Asian Americans in admissions controversies, but I'm going to do so a little bit differently than is often done. You all may be familiar with the whole model minority stereotype of Asian Americans as high achievers, and how, Asian American achievement is often pitted against, say, Black, Latina underachievement. People say, or opponents of affirmative action say, well, look, Asian Americans can do so well in their minority group. Why can't Black and Latinos pull themselves up? That is part of the entire rubric of all of admissions cases in elite university admissions, and also in public magnet school admissions that I will get into. And I think, that's something I've written a lot about and is very important in this whole dynamic. But I'm going to talk about something a little bit different. The idea of Asian Americans' academic achievement as a threat to white dominance, and how that has played a role in all of these elite admissions controversies. Now, who was the first legal scholar to talk about this issue? Well, it was none other than founding figure of critical race theory, Professor Derek Bell, who way back in 1987, in this essay in his book, And We Are Not Saved, said basically, when their status as mainly white institutions was threatened, elite colleges faced with a growing number of highly qualified Asian students began changing the definition of merit. So what did Professor Bell mean? Well, he meant, colleges, universities, elite colleges, universities, started putting a little bit less emphasis on grades and standardized tests, and started looking at holistic criteria, diversity a bit more, and suggested part of that was because the number of Asian American students was growing, and to maintain their status as white institutions, we had to stop having too many Asian students. And he said the same thing about Black and Latino students. That's what this essay was actually about. But I'll note Professor Bell was no fan of standardized tests. I worked with him, at NYU School of Law. I knew him well. But he still recognized, maybe some of this less emphasis on standardized tests. Maybe we like it for some reasons, but we know part of the reasons it's happening is because elite whites feel threatened by the growing presence of Asian Americans. And anyone who knew Professor Bell knew that he often dealt with these kinds of controversies and conflicted issues where you have different kind of complex racial dynamics going on. So what I'm going to do is I'm going to kind of give a little history here, going back to the 1980s, to that era when Professor Bell was writing about this. So early 1980s, you have many Asian Americans enrolling at elite universities. This goes back to the Immigration Act of 1965, which brought kind of a class of educated Asian immigrants to this country. Eventually, their kids are going to school. But this led to resentment among white students. Thought Asian Americans are these curve breakers. They study too much and they make things harder for us. And different campuses were labeled with these epithets. MIT was called Made in Taiwan. UCLA, right here, University of Caucasians Living Among Asians. I don't know if that's still out there, but in the 1980s, that's how UCLA was referred to. And in this context, elite universities were accused of discriminating against Asian Americans in favor of white Americans. There were investigations at a number of elite schools, Brown, Harvard, Princeton, Stanford, Berkeley, UCLA, and guess which school was found liable actually for discriminating against 5 Asian American students? That's right, UCLA. In 1989, by the Office of Civil Rights, the Department of Education was ordered to admit 5 Asian students who had been excluded. But I really want to focus on the anti-Asian animus, kind of the overt evidence of this, that this resentment is there in different places. So let's look at Brown University here. Just one example back in the 80s. Asian American students, staff said, admissions discussions often had racial stereotyping, negative sentiments to Asian Americans. The admissions director allegedly said Brown could shrink its admitted class by, quote unquote, cutting the first 10 Kims off the top of the list. So Brown's Committee on Minority Affairs investigated, made a number of recommendations, like let's evaluate the admissions process, let's make sure Asian Americans are participating in the process. Now mind you, Asian Americans are very well represented at Brown at this time, but still when you have comments like this, that causes concern. The Asian American Student Association wanted the admissions director, Rogers, to be fired. He was not fired, didn't recommend his termination. And part of that, why do I mention that? Part of the idea here, dynamic, is that Asian American students thought, animus towards us is not taken very seriously. He made this remark and there were really no consequences for it. Princeton University also, Professor Uwe Reinhardt, talked about discussion during an admissions committee meeting of qualified Asian American graduate student, and some of the members said, well, we have enough of them. You have to admit there are a lot, kind of suggesting there is a limit on the number of Asian American students who should be admitted. And there was some, there was a concern about this from Asian American scholars, including those who supported affirmative action. Professor Ling-Chi Wang, founder of the Berkeley Ethnic Studies Department and of Chinese for Affirmative Action, basically says university officials see the prevalence of Asians as a problem. Are they scared of Berkeley's becoming an Asian university? They're shaking in their socks. And he compared, actually Ling-Chi Wang was the first to compare, maybe not the first, but he compared the limits on the number of Asian Americans that he was talking about to the limits on the number of Jews back in the early and mid 20th century. That is an analogy that SFFA used in their litigation in SFFA v. Harvard. And I got to bring it back to UCLA again. Don Nakanishi, director of the UCLA Asian American Studies program from 1990 to 2010. Quote from him, Asian Americans, in essence, have become victims of their own academic success. They're viewed as a threat. We now have university administrators worrying about Caucasians becoming underrepresented and about how to curb the decline of white students in the UC system. So all of this is happening in the 1980s. Another UCLA connection here, Professor Jerry Kahn, who I'm sure many of you know, made this distinction between affirmative action, he did this about 1995, 96 was when he published this article, policies, practices like race-conscious admissions, which benefit underrepresented applicants in university admissions, and contrasted that with negative action, which are policies, practices, which disadvantage Asian American applicants in comparison to similarly situated white applicants. So he's making this distinction, and there is a distinction there, 1980s, Ling Chi Wang, Don Nakanishi were talking about negative action, not affirmative action. They were supporters of affirmative action, so was Derek Bell. So they were all talking about negative action. But how much can we distinguish between the two? I'm laying it out here, I'm trying to lay it out here clearly. But let's see. So let me go to SFFA v. Harvard. Well, they use negative action and affirmative action. And I'm going back to the kind of beginning of the litigation, back to the claims in their complaint. Part one was solely a claim of negative action. Very much white applicants are intentionally favored over Asian American applicants. That was their argument. They did not incorporate black or Latina students. That's exactly how they framed the argument. And they had a lot of statistical models showing how Asian Americans were disfavored. Harvard denied that they were doing this, so burden was on SFFA to prove it. But the second part was the attack on affirmative action, that Harvard's race-conscious policy violated the law, and Harvard admitted we use a race-conscious policy, so that triggered strict scrutiny. SFFA initially wanted to remove any references to race from college applications. That was their initial remedy sought, which would stop affirmative action and stop negative action if you don't know the applicant's race at all. But they changed that position at the Supreme Court and said it's okay to have essays that mention race. So there goes the remedy for negative action. The personal rating, Harvard's personal rating, also came up in this litigation. Basically, this evaluates character traits, humor, sensitivity, leadership, etc. And Asian Americans were rated lower than other groups on the personal rating. But what I want to talk about, again, I'm talking about kind of overt anti-Asian animus. Everything I just talked about now, personal rating, raised some questions. But there are different explanations for that, or at least discrimination was not proven. But if you really dig into SFFA v. Harvard, and I did, I've written a lot about this, go to the Statement of Undisputed Facts. One thing that came out of this litigation, and all these investigations that the Trump administration is doing, is really, let's find some information that we can use against these universities. SFFA was doing that, the Trump administration is doing that. So here is something that they uncovered. 2012 letter from a 1942 Harvard alum to Harvard President Drew Faust. Basically said, what did the alum say? He urged Harvard to adopt informal quotas on foreign students, limit the number of Japanese students to a certain percentage, have a quota based on religious affiliation and skin color. None of this, of course, has to go beyond the dean's office, and these students should be limited to 5%. So what was the response? That's what this alum said. Response from the admissions director. President Faust has asked me to respond to your April 4th letter in which you offered many thoughtful observations about Harvard, college, et cetera, et cetera. All of us at Harvard appreciate your thoughtful letter. Now, President Faust privately did acknowledge this is preposterous. Of course, we're not going to do this. But said, okay, he's 90 years old. He probably fought in World War II. We can understand where his ideas are coming from. But this came out in the litigation. She thought it wouldn't. And when she was deposed, SFFA asked her, well, if this was African Americans, if an alum sent you something like this with this kind of sentiments about African Americans, would you have just sent him a polite letter back? She did not answer the question. She declined to answer the question. But again, this goes back to, well, the idea, you're not taking discrimination against Asian Americans very seriously. Now, I want to talk just a little bit about the next set of cases that are coming up, magnet school admissions that are being challenged. Before I do that, though, let me get into, I'll be able to get to that. Just this idea of K through 12 education. The next set of challenges to diversity admissions are to K through 12 schools, particularly public magnet, middle schools, and high schools. And this is happening in the context, again, of Asian American students seen as too academically competitive. There's this phenomenon called the new white flight, where white families are fleeing from high-performing school districts, actually. Conventionally, white flight is white families getting away from black and Latino families in poor school districts. This is happening here in California, Silicon Valley, also happening in Johns Creek, Georgia. This is documented. Wall Street Journal first documented this 20 years ago. Why are white parents leaving? What explanations they give? Asian parents take their kids for extra tutoring. It's not fair for the quote-unquote regular kids. High school's too competitive. My kids can't get into a good college because of all the Asians. So this phenomenon is documented, and in fact, 2023 study in California showed that this is a reason why white families are leaving relatively affluent school districts. As I said, there are a number of studies that are coming up. This is kind of becoming a hot issue in sociology. A lot of people are studying this. So let me move to the magnet school, high school and middle school admissions cases. There's a number of these cases where admissions policies to elite magnet schools are being challenged. And they kind of have a general profile, so I'll just give it. So public magnet school, high school, has a high Asian American enrollment, much beyond the representation in the community. So admissions policy is changed to get more diversity. Now these magnet school admissions, they don't use race. So they're different from SFFA, from university admissions. Race is not a factor, but you can do different things to increase diversity. Eliminate standardized tests. Standardized tests is always in this. Have more holistic review, use geographic socioeconomic criteria, and the primary motivation is to increase representation of underrepresented groups. That's what the school board wants to do. But again, that anti-Asian animus is in this whole mix here. Too many Asian Americans here. So change the admissions policy, Asian American admission drops, but still remains very high. All other groups, including whites, increase. Asian American parents challenge the policy, saying that there was an impermissible racial motive, that part of the motivation was actually to limit the number of Asian Americans. And there are conservative organizations litigating these cases. And my recent California Law Review article really goes into these, and particularly one case, Coalition 4TJ, the Fairfax County School Board. And I'm just about out of time here. I am out of time, but let me just show, just some of the things that came out in this case. At the statewide education reform meeting, Asian American families referred to ravenous and unethical. One teacher referred specifically to immigrant families from India and suggested they may have come here illegally. And there were text messages between board members that suggested that they harbored anti-Asian animus. But the major motivation for this policy was to increase diversity. But what do you do when this anti-Asian animus is mixed in there? And I think, I'm out of time, so I will stop there with that question. Thank you.
Well, first of all, I wanted to thank everyone who contributed to this event. It's really been marvelous to be here. I've learned so much already, and I'm hoping to learn even more by sharing with you this paper that I've been working on, and I'm very eager to get your feedback because it is truly a work in progress, and I'll have some questions for you at the end, which I hope we can talk about afterwards. So the first thing is that this is a story about SFFA, and the way that the court constructed race. And the title is How Race Became Illegible, which apparently hasn't been well received. So I'm very curious. One of my questions will be, do you think of a better title? But I wanted to go through with you today, and it's been very helpful to have these earlier presentations, the exceptional nature of the use of race for affirmative action in higher education admissions. Because once you appreciate just how unusual the deployment of race was, you can also understand why there are significant limits on SFFA and how it is being both overinterpreted and underinterpreted in subsequent developments. So let me first start by saying that affirmative action in higher education was not focused on a history of discriminatory intent. So that immediately makes this very different. Instead, universities were able to use race for the very reasons that Ruben was describing, a diversity rationale, to predict an applicant's viewpoint and experience, to contribute to the robust exchange of ideas. And so, in effect, we were not using race as a label to identify a member of a group who had been harmed. We were using race to make group-based inferences about an individual applicant's beliefs, experiences, and attitudes. Now, that was a prophylactic use. It wasn't correcting the institution's own wrongs, but instead it was trying to achieve a more robust exchange of ideas, a First Amendment grounded rationale rooted in university autonomy. And I think one aside here is that the death of affirmative action has coincided with significant assaults on university autonomy. That may not be accidental. And while I say here that the use of race was broadly prophylactic, I don't mean to say that it was truly, broad in the sense that you could correct societal injustice. The court specifically rejected that broad prophylactic use, but it nonetheless was meant to prevent a narrowing of ideas in the academy. Now, that exceptionalism really should limit the decision's impact, because when you look at what the court said, it did not say across the board that we have to be colorblind, that race is always irrelevant. In fact, the court explicitly acknowledged that race is relevant to correcting past discrimination. It also recognized that race was relevant in managing unruly people in prison. So it did not exclude completely the use of race. So it did not make a strong normative claim of colorblindness. Instead, it engaged in an empirical exercise and said that race was not well suited to making group-based inferences about people's beliefs and attitudes. So it questioned the utility of race in making group-based inferences, but it didn't say that we are uniformly involved with a colorblind regime. So I think that's the first really important limitation of the decision. It's really empirically grounded. It's not a strong normative claim. Now, the other interesting feature for me of the case is that it is so agnostic about history, with the exception of Justice Ketanji Brown Jackson's dissent. But if you look at the majority opinion and the concurrence by Justice Gorsuch and they say very little about the history of racial categories. The ones that they are saying are incoherent and incomprehensible. And so part of the paper is an effort to show how this very narrow group-based inference use of race has very little to do with the way that racial categories were constructed in the past. And drawing selectively on the history of racial categories, I argue that these were not ever designed to make group-based inferences about individuals, but rather were based on a desire to identify and subordinate groups as groups. And I draw, for example, on the history of Jews in the United States and their ambiguous whiteness and the ways that boundaries were drawn to select them into a more privileged group and not keep them out and put them in a more disadvantaged group. So I argue that race has really been a group-based phenomenon, not based on some desire to figure out how particular individuals behave. In fact, it's meant to erase individual difference by using a broad category. Secondly, that although the use of race in SFFA was prophylactic, designed to improve representation and the exchange of ideas, the use of race historically has primarily been punitive to construct a caste system, and here I draw heavily on the Black experience with slavery, Reconstruction, the end of Reconstruction, and then the push for civil rights. Now, the other thing that I try to point out is that the self-identification, which is used in admissions processes and which the court took to task as an opportunity for improper gaming of the system. We just heard about Asian applicants. One example the court gave was that Asian applicants had been advised to downplay their identity to get admitted, and they worried that self-identification would lead to gaming of the system. Well, historically, race wasn't used based on self-identification. There was an external identifier, for example, a census enumerator, who would decide what race you were. You didn't have the autonomy to choose your race. It was imposed upon you. And the fact that race more recently has relied on self-identification, that we have seen groups mobilize around their identities, Asian Americans and Latinos, to create pan-ethnic categories which they claim for themselves, is a relatively new phenomenon. And so to ignore the history of race and to act as though the story of its use in affirmative action is the whole story is itself a kind of violation, I think, of the meaning of racial categories. Now, I did say that I was going to look into both the overinterpretation and the underinterpretation of SFFA. And so the first thing that I think is a severe overrepresentation is the notion that the case ushered in a regime of colorblindness, normative colorblindness. And so that actually, I don't think is true, but it has been used to justify all-out war on reverse discrimination, the very kind of discrimination that has just been described, but which is also involving mistreatment of whites. So it's a kind of broad rubric, and we heard about a little bit about this concern, but what we see now is not express animus. What we see now is, for example, the Trump administration demanding that every college and university provide racial data, and it is provided for applicants, admitted students, and those who enroll. And you also are going to be gathering from these universities their GPAs and standardized test scores to ferret out illicit reverse discrimination. That is the entire goal. It has nothing to do with overt animus and everything to do with some assumption that if there's any deviation from a grades and test score driven result, that it must be the result of reverse discrimination. And so this is a very dramatic expansion, I think, of the opinion beyond anything that it said. And it also denies in some ways the relevance of holistic review and says it's really all about your race, ethnicity, grade point average, and test scores. So what we see now is a hearkening back to group-based distinctions as the court uses these data to put together group profiles and then behave punitively towards universities that somehow include too many African Americans or Latinos in their student body. Now, the other thing that I wanted to build on here is that the effort to root out reverse discrimination has grown so kind of inflated, I think, has grown so dramatically that even race-neutral processes on their face are not safe. These go back to the magnet cases that were just mentioned, and here what we see is that when a school district attempts to use race-neutral criteria, socioeconomic status, immigrant status, language other than English, income, socioeconomic status, that the court has said that if you're using, the courts are, well, advocates have said, and some courts have agreed, that if you use those race-neutral criteria in a way that might advance racial representation, they must be, therefore, reverse discrimination. And that claim, of course, means that now you may not name race as a basis for disadvantage, but racial proxies are also impermissible. And one of the interesting things that I heard in this conference was that this kind of combination of race and adjacent kind of cultural race has long been a feature of our racial hierarchy. And what this does is it divests groups of the autonomy to name themselves even through characteristics that are not explicitly racial because they look too racial. So it's actually, instead of SFFA eliminating racial categories, it's intensified data collection on race and it is expanding the idea of what counts as race in admissions processes. The underinterpretation of SFFA. Now, what I found fascinating about this decision is that it said that race can still be used for profiling in law enforcement. That was what I read when they referred to the Johnson case, which said you could segregate people by race in prison to prevent prison riots. And I think that the court is coming through on the claim that you can use a group-based inference to make judgments about whether, for example, someone is illegally in the United States, and also for other purposes. But I'm going to use this because it's a recent decision. And here, you know, in this decision on the emergency or shadow docket, there was no opinion, but there were staking out of territory intellectually because this is going to come back. And the Kavanaugh opinion basically said, oh, well, we cannot profile based on race alone. But look here, you know, there were 3 other characteristics: that you spoke accented English or no English at all, that you worked in a low-wage job, or that you were in a site where people who seek, labor in a gray market like a Home Depot. Well, that, along with the fact that you look Mexican, that or Latino or whatever, that's enough. That's legitimate for profiling because we have race plus. And he said, of course, it's race plus in the context of Los Angeles, where we are right now, where these characteristics are unusually predictive. Now, Justice Sotomayor, in her dissent, pointed out that the vast majority of people who meet those criteria are actually legally here. Super majority, not just it's not even close. So there was a debate about the empirics. But what I found very interesting was that there was not much discussion about how this is completely antithetical to the claim that group-based inferences based on race are useless. In a situation where race plus was far more robust, holistic review involves many more than 4 criteria, and yet that was completely inadequate to make predictions about individuals. But here, there's a willingness to use a much less robust version for punitive purposes. Now, when I think about this, I think one argument that might have been lurking in SFFA is that when you use race, you've got to be very careful about group-based inferences. But there isn't any real care here with respect to their punitive uses. I do want to say, in all fairness to the court, I think their approach to group-based inferences in non-racial contexts is also a mess. But here, I think the contradictions cannot be ignored. So to me, this is an underinterpretation of SFFA. Now, here are my questions for you. You already got one, which is, I don't think the title maybe works. So if you're one of those people who really has good ideas for titles, I'd love to hear that. I'd also like to know what you think about the structure of the arguments, whether they really hold together and cohere. And finally, if there are any additional resources, because I know we have many, many very significant experts here today. If you have any resources you would like to share with me about this, I would welcome them. And so I want to thank you for your time. Good morning. Can everyone hear me okay? All right.
Yep.
First of all, I want to echo everyone else's sentiments of how glad I am to be here this morning amongst you all, how humbled I am to serve on such an illustrious panel. I'll try to sort of hold my keep a little bit, but I'm also going to be staking out a little bit of a different area. So my presentation is really a little bit less of the legal ramifications of SFFA and more how they are a reflection of and how they help to constitute our understanding of a few key terms like diversity, affirmative action, and merit. So first of all, I'm rooting this in a rhetorical concept, Michael Calvin McGee's concept of the ideograph.
which in short, I'm going to go through it in a few stages, assuming that it's not necessarily something that everyone here might be familiar with. But they, in general, link rhetoric and ideology. They are ordinary words that shape public consciousness, and they persuade through cultural conditioning, not overt argument. And so McGee breaks this down into sort of 4 key characteristics. They are part of ordinary language, not specialized jargon. They have a high order abstraction, right? They're highly abstract terms that link a single, stable, concrete referent. So the ambiguity is a source of strength as it allows different audiences to project their own meanings onto the term, thereby building broad but internally contradictory coalitions of support. The fuzziness of an ideograph is the source of its political unity. The ideographs tend to warrant power and guide behaviors. They're used to justify the exercise of power and to excuse beliefs or actions that might otherwise be seen as antisocial or eccentric. They channel public behavior into socially approved pathways, which apply to both positive ideographs, which I'll call God terms, and which call for laudable action. For example, defending freedom is often considered a God term. And negative ideographs, which brand behavior as unacceptable. So in other words, it's still a positive function, but we might want to combat tyranny or terrorism, right? And so those are double terms. Ideographs are culture bound. So the meaning and potency of an ideograph is contingent upon the specific historical and cultural context in which it is used. And so then further, along with these sort of 5 characteristics, there's 2 dimensions of meaning. Diachronic, which is a vertical axis, which explores the historical evolution of a term. And then synchronic, horizontal analysis, which examines the meaning at a moment in time by analyzing its relationship to other ideographs currently in circulation. And so I'm going to look at both of those. And so really just to sort of reiterate, the power of an ideograph lies in its semantic ambiguity, right? So in other words, we all can say that we might value something like diversity or merit or equality, but we might have very different views on what constitute each of these terms. And so this leads to a constitutional paradox, right? So if the rhetorical strength derives its power from ambiguity, but it becomes legally vulnerable, right? Because strict scrutiny demands compelling and narrowly tailored interests with clear, measurable definitions, right? So these 2 are in some ways inherently contradictory. And so inevitably there will be a rupture. And so this is what I argue that SFFA, I won't say that SFFA causes the rupture, but it is a symbol of this rupture of the conflict between ambiguity and then trying to pin down some sort of a compelling and narrowly tailored interest. And so we can see a few ideographs that are at play in SFFA, and actually in the general sort of rhetoric surrounding the decision as well, right? So we know that we've been ably sort of taken through diversity as an educational benefit, a First Amendment sort of right. But the lack of measurability and the lack of risk of stereotyping, as has already been talked about, right, are one of these ways that this is contested, right? Affirmative action, which we'll talk about a little bit too, right, which has been theorized as sort of a remedial justice active anti-discrimination term, has become this way of talking about reverse discrimination, right? So affirmative action has been linked now with what we call reverse discrimination. Additionally, a few other important ideographs that we've been talking about, things like adversity, which individualizes, for example, racial or social hardship rather than talking about it as a group. And then place context, which where we're trying to find some race-neutral way of understanding disadvantage. And so if we look at sort of the history of affirmative action, it begins not in education, but in President Kennedy's executive order, where he charged contractors to take affirmative action to ensure applicants are employed without regard to race. So this is an active anti-discrimination policy. And then the term affirmative action, which normally we would not think of as an ideograph because it is fairly specialized, actually comes into sort of popular parlance, right, as this shortcut way of saying to take affirmative steps towards inclusion. And then it sort of changed in the 1960s to the 1970s, right? And so the policies shifted to be a little bit more active. And then, as has been, again, ably discussed previously, right, the Bakke Compromise starts to decouple affirmative action from historical justice, and then we start to talk more about diversity. So this is where we start to potentially use the word diversity more often than affirmative action, although I'm going to argue that these two terms are intricately linked in what we're talking about, right? We use them sometimes interchangeably, and that's part of why we get such purchase into each of these terms. And then we have a rhetorical capture in the 1990s to the 2000s, right? That there starts to become a competing narrative of colorblindness. In other words, we want to eliminate discrimination in any way, including, quote unquote, reverse discrimination, right? And so affirmative action becomes one of those boogeymen in this term. And then, of course, we've been talking about sort of what happens with SFFA. And then so for a part of our analysis, too, is to understand that sort of the link of affirmative action and diversity. Diversity in its sort of original Latin roots was not a positive term. It signaled division, right? And I think this is interesting because I think this is one of the things that some folks are trying to bring back into our understanding of the word diversity, right? Linking it again to a division, even though it had for so long been transformed into a constitutional good, right? Some sort of goal that we were working towards. And again, this understanding of diversity has shifted over time as well. So one of the first people to really talk about it in terms of education was Harvard Dean Wilbur Bender, who said, diversity would mean some snobs and some Scandinavian farm boys and some bright Bronx pre-meds, right? And then it gets shifted in the civil rights movement to become more specifically linked to race-based diversity. And it gets expanded as well. But importantly, as we talked about in the Grutter decision, right, there's that 25-year sunset provision, right? And so as this becomes a goal, it also is a goal with a time limit. And so now we see one of the issues, and we see this in the Dear Colleague letter, that diversity as it coexists with equity and inclusion are sort of seen together, right? Each addressing a different question: what, how, and how it feels. And then diversity's meaning depends on its alliances and its opponents, meritocracy, and free speech. But as I argue, it has also subsumed affirmative action. These are seen very much together. So I'm going to sort of skip through because I think everyone else has been great about sort of talking about why diversity failed in SFFA. But talk about one of the bigger issues, which is that diversity became co-opted as in sort of the corporate and academic frames, right? So we know there are lots of empirical studies of how important diverse thought is to good decision making. And so this became an ideograph that was picked up in sort of the corporate talk about really growing a brand, making sure that better decisions were being made. Universities frame it as academic excellence and civic preparation. But both are transforming this moral discourse into a managerial strategy, and one that just reifies this background of education's purpose in the capitalist society, right? In other words, what we are trying to do is create more productive, better workers, and diversity is one way to do so. And so this is where I say, diversity gets a little bit co-opted as a palatable capitalist goal. And I think part of this is a way to reframe our discussions about admissions. We can keep merit as something that we're striving to achieve, and I think Professor Moran really ably talked about this as well, and play a shell game with what we mean by merit. And so we don't have to look at the fact that we're choosing standards that tend to reify positions of power, right? People who come from privilege are more likely to succeed well on things like standardized tests. We're reifying that while just sort of playing a shell game about how we're going to make it seem a little bit more merit-based, right? And diversity is one way to do this. And so part of what I've been looking at is the discourse around legacy admissions and the bump that you get if you come from alumni donors, right? And so these are just now being spoken to in the same breath. But I think it's really hard. We can't unlink our understanding of what merit might be with what we're talking about as far as admissions advantages. All right. And so I think we have a lot to learn about what's going on. I mean, obviously, I'm probably not the only one to think this, that some of the scholars in the past give us a lot to think about how important critical race theory is to understanding the issues behind this. And I'm going to sort of skip through a couple of these because I think that these are sort of have been aptly discussed, but I do want to sort of talk about about the ideological battlefield that we've been facing with, right? And so what I see now is that terms like diversity and DEI are increasingly weaponized. So what had been considered a moral good has now been argued to be a divisive issue, right? Diversity is coming back to being division rather than a multitude of voices. And so this is sort of the frame. So while some folks are thinking diversity, a great common good, the anti-woke playbook is arguing that this is part of the identity politics that we want to get away from, right? And so they're weaponizing acronyms. So DEI, which seems, like such a universally good goal, diversity, equity, inclusion. Who can argue against that? All of a sudden, this becomes sort of an indication of wokeness, right? And they're trying to put in, and this is not a new concept, but trying to put in this what I'm calling the incompetence trope, that somehow DEI does not indicate more merit, indicates less merit, right? Which again to me seems nonsensical, right? So what traditionally we've thought about is making sure that people are properly represented, that the fact that someone's background might not fully represent who they are, and we need to figure out how to fully represent people. This is now becoming, right, so we've seen this in the helicopter pilot discussion, right, that if you're a woman helicopter pilot and you're a DEI hire, then you are incompetent, right? And so this is this anti-woke, and again, nothing new. And so, so I know I'm running low on time, and I kind of wanted to wrap up a little bit. I have an appendix if we're really interested in more of my research, but I did want to sort of skip through. But I also wanted to say this is very much in its early stages. I really do welcome any questions or comments, and then there is a QR code to my LinkedIn if you'd like to connect. Thank you.
Wow, this is a lot. There's so many questions that I'm really looking forward to both the comments and responses of our panelists. But I'm going to take the opportunity as moderator to pose a couple of thoughts. Ruben and Rachel, I was thinking about your presentations as sort of situated in reminding us about how the structure of SFFA is treating race as something kind of exceptional. That is to say, Ruben, you point out that the sort of off-ramp, which may be a false flag or in some sense a kind of detour that's not really there, of the obstacle narrative, actually is treating race as a kind of individual attribute as distinct from a group-based understanding. And Rachel, you point out that there's a kind of fundamental, I guess I would say, incoherence in the original rationale around diversity, which invites a similar kind of move, right? So I was wondering if you guys would talk about how you see their if I'm right in seeing the connectivity there between those presentations and what the implications are. And Vinay, I thought your return to sort of Derek's question about the tension in the move away from merit as having its origins in kind of a dual kind of origin, coming from a racial justice position as well as coming from an institutional preservation position, in which a move away from merit towards holistic criteria was actually masking a certain amount of anti-Asian anxiety. And I wondered if there was similarly here, you left us with an intriguing question, which is the ability to distinguish between negative affirmative action and, or negative action versus affirmative action, the distinction that Jerry attempted to draw some time ago. And thinking about the problem that frame, I mean, I think an accurate empirical description, but the problem that frame presents as a kind of either-or question, when often what I think you may be presenting is a mixed motive case to some degree. And so I wonder if you would comment on that. I think also in terms of this point about the rhetorical register in which this occurs, Susan, is really interesting, because part of what I'm hearing you say is the instability of these meanings and categories and the ways in which they both constitute as well as are constantly trying to work around a certain kind of fundamental incoherence. The thing that I am struck by is, and this is maybe a little bit off the page, but thinking about a similar kind of incoherence and ambivalence in the context of voting rights, which is where the court has historically said or treated race as a cognizable category. That isn't sort of the question, but when it may be taken into account, and consequently constantly sort of trying to ride the line between a recognition of race as a group-based category, which is of course in tension with how it's presented elsewhere, at the same time trying to put race-conscious voting remedies in the same box as, so that's putting race-conscious remedies in the same box as segregation, but by the same point allowing for the fact that it can be taken into account. So that's a lot, but I could go on, but I'm not supposed to. So I'm going to let you guys react to and respond to those thoughts.
No, I think, Shirley, you're absolutely right in terms of seeing the connection that I think both of our papers sort of bring up, and so I look forward to talking to Rachel more about how those how that fits with what I'm doing. But I think I think there's a lot, of course, to say about group versus individualism in the Constitution, and I think it's definitely we have that kind of old saw. The Constitution protects individuals, but not not groups, and yet we know that all you could go through the litany of examples where that was not the case, and so I'm definitely trying to sort of cabin some of that. But I think Rachel's paper is absolutely right that there's an incoherence. Of course, there's an incoherence to a lot of SFFA, but that's another story, and that's another paper probably.
Well, I wanted to say that I do think that there's a connection between the idea that race is a somewhat, what Stuart Hall called a floating signifier, right? It's this amorphous concept that has allowed the court to game it, right? To select out the version of race that's most convenient for a particular case. And so that gaming is really interesting. What you also see here is that, they do say you can use it because obviously an essay is more predictive of your individual viewpoint than the group category. That's always going to be true. But what is fascinating, and I don't know if you can get the data, but I talked to someone who's a reviewer for Harvard, and they got explicit instructions that when you talk about race, you're not supposed to put that down. So it is only the hardship, and the race is getting eliminated through overinterpretation. That goes back to the ways in which institutional self-preservation affects the interpretation of the decision. So there are so many interesting connections across these papers.
Yes, Cheryl, I mean, that's the whole idea of mixed motive is kind of exactly what I'm getting at. I kind of talked about the examples of anti-Asian animus in my talk, but the other part of my paper, the kind of doctrinal part, is looking at this as a mixed motive situation, and that's the way I analyzed the Coalition for TJ, the major magnet school admissions case. Arlington Heights, the cases did deal with mixed motive. Of course, we have a Title VII precedent, but just thinking about it as a conceptual matter, what do we, how do we just view that type of situation? Let's say, everyone in this room is, part of the school board, and you're trying to decide whether to get rid of a standardized test or keep it as part of the admissions policy. Well, what if 3 people are motivated by anti-Asian animus, that Asian Americans are doing too well, we don't want so many of them, and everyone else we want more diversity, we want more racial equity. If it's just 2 or 3 people, and I think that was kind of the Coalition for TJ situation. It was a relatively small, you could do the balance of motives. But what if it was 50-50 or something like that? I mean, how do we deal with that situation? I'm still grappling with that. I think Arlington Heights, if you go to Arlington Heights, basically, in a mixed motive case, standard proof is, would the same decision have been made absent the impermissible motive? And I talk about that in my article here, so maybe that's a legal way to deal with it. But I think, there's more than a legal question here. What do we do when these different interests may be pitted in different ways? And I think it just, it's almost an entrenched problem in elite education when you have selective admissions, selective education, where the majority of people are going to be excluded. Someone is not going to be happy about what happens, and we're going to have this type of situation. I think it's inherent in elite selective admissions.
So I'm going to pick up a little bit on what he was just saying too, which is probably the most radical thing I keep coming back to is that we are sort of giving power to elite universities by buying into their merit-based narrative. When we know that it's not right. So first of all, again, merit I would argue is another ideograph, right? That we don't all agree what we mean by merit-based. But then I also wanted to reach into your original sort of thoughts about voting rights, and I absolutely agree, right? In other words, we operationalize folks like we can sort of understand everything about them by a few demographic categories, right? And when it's convenient, right? So we're going to redistrict based on race so that I can win, but then as soon as that becomes a challenge, as soon as we start to unpack what that means, then there's another way to understand race, or there's another way to understand the categories that makes it impermissible then to decide based on something like race. And I think it's the fact that so much of our sort of political and legal sort of leanings lately have been done in sound bites because these are very sort of complicated and overlapping issues that as soon as you start to sort of zoom in on one issue, right, so Kenneth Burke always talks about rhetorical lenses, and a way of seeing is a way of not seeing, right, that you zoom in on one issue and you have to sort of ignore the surrounding issues, and I think that's what we have whenever we focus in on any of these sorts of key issues.
Okay, questions, comments from the audience? In the back there.
Well, I should as well as other people of color. So one of the facts that I think is very much ignored in Fairfax County, for example, is that after it's certainly true that the overall percentage of Asian American students dropped, but what's really startling is that after the changes, the number of economically disadvantaged students that attended Thomas Jefferson High School went from less than 1% to 20%. And the percentage of Asian American students who went to underrepresented middle schools increased sixfold. It increased it 600%. So we have this group of Asian, a coalition that purportedly represents Asian Americans, to say that this is a process that is discriminating against Asian Americans. It's in fact discriminating against very privileged Asian Americans. And that's true in a place like Fairfax County, which is one of the most expensive school districts in the country, where where you go to school. I mean, I live in Fairfax County, so I know this personally. People choose where their house is before they even have a child because they know that their child is going to go to that middle school and then be funneled into the schools like Thomas Jefferson, as well as the other elite high schools there. So I think that is some of the conversation that I would really like to be included when we talk about Asian Americans, especially because that has often been used as an excuse to somehow justify criticisms of increasing the numbers of Black and Latino students who in fact are equally, talented and capable. It's just that they're facing discriminatory barriers. So that's one thing. And then the other thing I just also thought would be interesting for Professor Moran is that, the idea that the oppressor defining the race, or kind of like they're the ones that are categorized, right? I think one really stark example of that is SFFA, because this whole because the Asian American demographic is so diverse, and one of the arguments is that there's a big difference between a Chinese American student whose parents went to had PhDs versus someone from a Southeast Asian country whose parents or perhaps grandparents were refugees, and the opportunities they provide. So in their lawsuit against Yale University, so they filed a lawsuit against Yale after they filed a lawsuit against Harvard. It didn't pursue because there was it ended up settling, but because of the SFA decision. But if you look at that complaint, they actually divide. They say that there's discrimination against preferred Asian Americans, and then they take out certain groups of Asian Americans and call them non-preferred Asian Americans. So that when you do the statistical analysis that they often rely on, then they can kind of make that argument that they're talking about some sort of specific group. And so that's I think the use of Asian Americans, I think, is just it's just something that needs to be, I think, very critically observed and not kind of compared as just a general group, which is one reason why there's a movement to increase more data collection based on nationality and ethnicity among Asian Americans, which, by the way, is opposed by many Asian Americans, primarily Chinese Americans and many Americans. So, and there's reasons why, right? Because they can kind of benefit from being a part of a group that can be claimed having discrimination and yet continue to try to benefit from the privileges they have because of their proximity to whiteness that perhaps other groups within the Asian American category don't have. And then, of course, there's intense discrimination against other Asian Americans within that larger, kind of, there's interracial discrimination that's very prevalent.
Thank you so much for your comment. I just wanted to put one little additional footnote on your comment, which is something that we saw here in the wake of the change in admissions policy after 2009. The impact was not just on Black and Latino students, but on subgroups of Asian students. The Filipino population dropped significantly. We had many fewer numbers of Southeast Asian students, and so that was kind of lost, I think, in the larger debate. But Vinay, please.
Okay. No, I mean I think all of your comments are very astute, and getting to the, I think, complexities of the issues here. I think just the way Asian American is defined or who's included has a big role here. There are groups that often are put under the rubric of Asian American who are underrepresented. I think Filipino Americans being one. So how do you define the category? Native Hawaiians are sometimes included. Even East versus South Asian, should those groups be linked together? And I think, those who oppose diversity, oppose affirmative action have used that in one way. Those who support it have used it another way. So just the way the category gets defined. As far as kind of the socioeconomic privileges and proximity to whiteness, I'll just point out proximity to whiteness is different than whiteness itself. Those people who are proximate can also, we see this. It's kind of like this. I guess Eduardo Bonilla Silva called it honorary whiteness. It can always be taken away, and I think some of what I talked about here in terms of the anti-Asian animus, I think, does illustrate that. But really, the point I wanted to make is, there are these instances of anti-Asian animus. They are used by conservatives, and the progressives don't even address them. I think we have a problematic situation. We have a situation where, Asian Americans are asking, well, why aren't you talking about this? And conservatives will manipulate anything that progressives do not address. So I do think it's important to address. The socioeconomic issue, I think, is a little bit more complex. I think, you described Fairfax County and, Thomas Jefferson, and there's a lot of dynamics at play there also. You have families from India who may live in an affluent neighborhood, and they bring their relatives over or something, and they're living in the garage, because they want to have access to these, particular schools. But look at New York City. Look at the, specialized high school admissions test in New York City. 60% of the students, if I recall correctly, in the specialized high schools are at the poverty level. So in different places, the socioeconomic dynamics play out differently. And I think the one thing about the magnet school admissions cases versus, say, SFFA v. Harvard, the students who are competitive for Harvard but don't get in, they're probably going to get into another very elite school. In these magnet school cases, there's not as many options. You can't move around the country. You can't go to different schools. So it's almost more high stakes in that way. So the socioeconomic dimension is a bit more warped. And there's really a lot of things going on in these cases. I'll plug my little article here, the California Law Review, where I talk about a lot of other things. But I don't want to take up too much time. So.
Can I just add to that
Sure.
quickly? One of the things that I think is really interesting about SFFA is that they don't talk about the reverse discrimination against Asians, because if they did, they would have to admit that the incoherence of the categories would make that incoherent. And so they're very carefully cabining off that issue so that they can continue to police reverse discrimination. The other thing that I wanted to say is that in the magnet school cases, one of the things that I've been astonished by is the lack of sophistication in presenting the statistical claims. There hasn't been much borrowing, for example, from employment discrimination. And so there's no discussion of the baselines. Like, why is it that the baseline isn't the student population and its demographics, rather than the baseline being who gets in with these certain grades and test scores? So, part of this is also a breakdown, I think, in our understanding of the public school as a common school, rather than a commodity that everybody can game to get. But I have just been astonished, and I'd be curious to know why there has been so little, even a test of statistical significance. The assumption was any disparity that hurts me is reverse discrimination. So it's a very weak framework for evaluating whether, in fact, any harm occurred, or whether it was just a result of either a different baseline. And there's really no evidence also of deferring to the school board on pedagogical matters, which I find also very interesting, as though they can't be trusted on racial issues, just as the universities were treated as untrustworthy. So I think there's a lot of interesting consonances. I thank you for the question.
Other questions? Yes.
I have two questions. First, directly towards Susan. Could you take a minute to define reification? And it's my understanding of it is a pretty complex term from critical theory. And then the second question I'll put to the audience. When we talk about the floating signifier and the ideograms, I was thinking about from the canonical CRT literature, Professor Crenshaw's intervention in response to Mark Tushnet, who critiqued rights litigation. He was pointing to the instability of these concepts, and Professor Crenshaw, from what I something, right? Yeah, and that was years ago. What do we, now that we know that what the game is, and we probably knew it then, but what have we learned since then about rights? And I guess, how do we deal with this? One thing that I think we can do is, play a more active role in public discourse, so that, because ultimately these meanings that they import into these floating signifiers come from what we understand, the public understands these things to mean. And so if we, develop a more robust record of, things that are happening in the world, we can maybe pin these down in a way that we need for them to be pinned down. That's one way to solve this problem, but I'd be interested in other interventions to deal with this instability problem.
Susan?
I'll start with, reification, as I'm meaning it, is sort of this retrenchment. In other words, there are certain things that we subscribe to that help to further define the category, right? In other words, it becomes right. So for example, whenever we use the term diversity, we might be meaning something, but then it also retrenches sort of that understanding, right? So just our active, for example, using the term diversity is going to be calling back to how it's been used in the past. We might be trying to sort of shape meaning, but we're also reinscribing power relationships, right, and sort of retrenching that term, and so that's always that conflict that we're going to be having. So we might be pushing against it, but at the same time, sort of re-entrenching ourselves in that. And I think that this is difficult too. In what you said about sort of tying down meaning, part of the reason that I did want to sort of talk about the ideograph is because there's a special rhetorical importance in not tying down the meaning, right? In other words, we find this, right? We find this with in-group fighting with any affinity group, right? As soon as we try and define what our principles are, right, we start to fight amongst ourselves. And so I think that there is a persuasive power in not tying down the meaning, but at least pushing back from these, what I would call very perverse sort of hijacking of these terms by groups that are really trying to sort of push back. And one of the other ideographs I've been thinking about is just fairness, right? And how we all agree that something should be fair, and there are so many competing versions of what fairness would look like in admissions, right?
As well as terms like preference. Other questions? Yes.
Or find people, whether it's SFFA or the Kennedy football coach case, or there's just a whole host of examples, right? Hobby Lobby is something where the court, right, takes a case and says, you believe you are harmed by this. It doesn't matter that these things harm abortion, right? There's no medical basis for it. Your belief, that's sufficient. And in the reverse, Daniel sitting here, right, Rahimi is a case where, in the Second Amendment, they had this terrible opinion brewing. A public defender is just doing their job, and the court is forced to change, sort of, because they're like, here's this terrible person, right? This is not who we would select to have as our next Second Amendment case, but we can't have this person have a gun, right? And so I'm just wondering, how do we get the right kinds of plaintiffs and challengers up to the Supreme Court to sort of force their hand in some situations?
I think it's a structural disadvantage that we find ourselves in, which is we're trying to preserve something that is, and expand. efforts, and so it's hard to conceive of a kind of a litigation strategy. I think that basically, what we heard, is a lot about sort of getting back in the dialogue, and in my particular piece, talking about these, actually kind of shape the narrative, right, in sort of a very CRT kind of way to shape the narrative of obstacle and, other, again, drawing on what Susan said. So I think it's a lot of different things, but I don't think we're going to get very far in terms of trying to come up with a litigation strategy for this. I think a lot of it is unfortunately defensive, and so that's just the place we find ourselves in, and we also may find ourselves out of time, actually.
Yeah, I just have a quick.
Yes, one last comment.
Well, just very quickly, one is, I think that one thing that I've critiqued is the notion that the expressive harms of standing that have been used to allow people to sue and challenge affirmative action, even though it wasn't clear they would get into the class, even without it, that should no longer be available when the criteria are race neutral, because there is no expressive harm at that point, and therefore you should have to show an actual injury. That would reduce the number of challenges that can go forward to a race-neutral, facially race-neutral process. The other thing I'm afraid of right now is collusion to make the system non-adversarial. So the Texas DREAM Act was just nullified. The Department of Justice filed a complaint. Within 3 hours, the Texas Attorney General said, we agree, this is actually impermissible. And the interveners have been denied the right to have a voice in the case, and that's on appeal to the Fifth Circuit. Meanwhile, in Tennessee, the Department of Education said, we're not defending Hispanic serving institutions. Fortunately, after a long delay and a lot of doubt, they actually granted on a permissive ground the intervention instead of intervention of right, which means the courts will be able to decide when, in these non-adversarial cases, an intervener can have some voice in protecting these programs. So I'm actually worried also about cases not getting anywhere, and that it's a very scary thing to see these kind of sort of, in Texas it felt collusive, but in general, just potentially very non-adversarial settings, because you strategically go to the state where that'll be a sympathetic judge, and then the federal administration says, or the state, we don't defend it, and then intervention isn't treated as of right. So I think that's a really interesting development too.
Thank you so much. I appreciate all of your comments.
Stay where you are.
Oh, okay.
All right.
Todd's going to get a picture.